discussion.
Justice Reyes.
Good afternoon, Congressman Lagman.
Good afternoon, Your Honor.
Section 12, Article 2 of the Constitution recognizes, among others, the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of unborn, not unborn child, from conception. Now, am I correct with my understanding that when the Constitution says that it shall protect the life of the unborn from conception, it does not say that from the moment the sperm and the egg shake hands, human life is already present. Am I correct to...
The Constitution is silent on that, Your Honor. It's very clear that the Constitution said from conception.
And it is from the moment of fertilization, the ovum should be treated as life. Am I correct with my understanding?
The Constitution does not say that, Your Honor.
So it is the...
It says that the state shall equally protect the life of the mother and the life of the unborn from conception.
So when is the life of the unborn begins?
Well, if we have to read the Constitution, then it's from conception, because that is the time the unborn is protected. But as we have said, Your Honor, it is not really important to resolve that issue when life begins, because under the reproductive health law, the contraceptive's principal function would be to inhibit ovulation or prevent the sperm from fertilizing the egg, in which case there is no fertilized ovum yet. But it extends its protection to the implantation of the fertilized ovum. So it would not be necessary anymore whether when life begins should be determined. I strongly suggest that the issues on constitutionality raised by the petitions can be resolved without adjudicating that issue on when life begins, which is more in the domain of medical science. That's why the Constitution did not even say when life begins.
But when the life was expelled from the mother's womb, there is a felony of abortion.
Yes, Your Honor, because once the fertilized ovum implants on the mother's womb, then conception begins or pregnancy begins. And it is only upon implantation of the fertilized ovum that pregnancy can be detected. There is a test for pregnancy after implantation, but there is no test for fertilization.
Because the unborn is already a separate body from the mother's womb. Am I right to state that? Because there is life, but there is no personality yet.
Yes,
that's what the Constitution says unborn. It does not say unborn child.
Yes, Your Honor. And I think there is reason for that. Because the unborn at that moment may not be a child, but is still unborn, and it has from conception it has to be protected. And according to the civil code, it will get all favorable things from conception once it is born alive.
Thus, any direct killing of the unborn from the moment of conception would be against our Constitution. That is
Yes.
my understanding.
Yes, Your Honor.
And am I right or correct to say that contraceptives are preventive in nature and character, as there is no unborn yet? Is that a correct statement,
Yes, Your Honor. It's
Mr. Congressman?
it prevents fertilization because it inhibits ovulation. If there are no eggs produced, then there can be no fertilization. And even if there are eggs produced, if the sperm is inhibited or prevented from fertilizing the egg, then there is no fertilization. In other words, Your Honor, the principal action of contraceptives prior to fertilization would be completely legal, and because there is no unborn to be protected at that moment.
That preventive pregnancy can still be covered under what we call population control policy.
Well, Your Honor, we have said in the law that the reproductive health law is not a population control policy. It has no demographic targets. It does not fix any population growth rate. And the central idea in the reproductive health law is freedom of informed choice. And if there is freedom of informed choice, there can be no population control.
All right. Would you agree with me, Mr. Congressman, that Section 4 of Republic Act 10354, which defines abortifacient as any drug or device that induces abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb, is the destruction of the unborn and is therefore illegal and unconstitutional?
Well,
Is that a precise statement or understanding of that particular section of the law, Mr. Congressman?
I think the definition, Your Honor, can be divided into two. One is the traditional meaning of abortifacient, which is the use of this drug or device would result to the expulsion of the fetus or embryo from the mother's womb before it becomes viable. That's the first part. The second part is an innovative definition of abortifacient because it would encompass drugs and devices which would prevent the implantation of the fertilized ovum in the mother's womb. And the destruction of that fertilized ovum is virtually a prevention of its implantation. Because if it is destroyed, then it cannot be implanted. But this is a third mechanism of action which we would hasten to say is not yet medically validated. But we acceded to that proposition as a concession to the critics of the RH bill. And we are leaving the determination of the third mechanism of action to the Food and Drugs Administration.
So based on your disposition, it would be right for me to assume that the constitutional intent to prohibit the passage of abortion statute and not the contraceptive statute like this RH bill.
One of the very important arguments to show that the RH law is against abortion is the definition provided for in Section 4A. It really gives protection to the fertilized ovum even before it becomes a fetus or an embryo. I think we are the only country in the world at the moment which has this innovative definition of abortifacient. But if we will have to err in favor of protection of the unborn, then we must. And that is a protection of the unborn.
Now, would you agree with me, Mr. Congressman, that at the moment, we are almost 100 million in terms of population?
Yes, Your Honor.
And per NEDA data, there are more than 25, about 50%, more than 50% of the populations belongs to the poor and the underprivileged families.
Yes, Your Honor.
And out of more than 50% of that population, about 28% of which belongs also to a level which is even below the poverty line.
Yes, Your Honor.
That when Congress envisioned this RH bill law more than 10 years ago, this is about almost 13 years ago, as you said, it had in mind foremost the plight of the poor families.
Among others, Your
Among
Honor.
others.
Among others, Your Honor.
And that statistics-wise, these families who belong to the poorest strata in our society have more children than like us, who are educated and who at least belong to the above middle class, medium middle class, light middle class, and the average class. Would you agree with me?
That is perfectly correct statement, Your Honor.
And in enacting this law, you also consider the provision in our Constitution about the Equal Protection Clause.
Yes, Your
Because
Honor.
there could be some basic violations you might commit in enacting that particular law. Am I correct to state that?
We have not transgressed, Your Honor, in enacting the law.
No, I'm not saying that, but you consider
Yeah, we did consider.
the Equal Protection Clause of
We
the
did consider,
Constitution.
Your Honor. We did consider.
That under the Equal Protection Clause of the Constitution, it does not require the universal applications of the law on all persons or things without distinctions.
If there is a proper distinction, then there is no breach of the Equal Protection Clause.
So you are saying is there is a appropriate or proper distinctions.
Yes, Your Honor.
Am I correct to assume that you are referring to the status of the various families, meaning to say that distinctions between the very poor and the underprivileged and those who belong to the affluent and the middle classes of our society?
Yes, Your Honor.
Would you consider that as
the differences among the
differences?
different quintiles?
Now, many proponents of the anti-RH law consider to downsize our population. Is that accurate?
No, Your Honor. No, Your Honor.
No, the
because
proponent of
that would be
the anti-RH law.
Yeah, because as far as the RH advocates are concerned, the proponents of the law, we are not having any demographic target or downsizing of the population, because the mitigation or the stabilization or even promotion of population growth would be a result of the promotion of reproductive health, and that is provided for in the law.
So do I get you right, Mr. Congressman, that the proponents of the RH law are not very particular about the current increase in the populations of our country.
Well, we assume, Your Honor, that if we give women and couples the opportunity to exercise their basic human right to responsibly and freely determine the number of spacing of their children, then there would be a deceleration of the population, not as an objective, but as a result of promoting reproductive health. Because surveys after surveys would show that women, particularly those in the marginalized and disadvantaged classes, would prefer less children or not to have any more additional children. But they don't have access, Your Honor, to reproductive health information, services, and supplies. And that is why we have envisioned this law in order to really remedy that gap on the contraceptive needs of our people, particularly the poor women.
What can you say about the proponents of the anti-RH bill, that instead of pouring billions of pesos for contraceptives, the government instead utilizes its resources in promoting the health, the education, and etc. of the population? What do you say about that?
That is a very contrived and unwarranted proposition, Your Honor. Because first, the RH law does not in any manner deny governments appropriating for other basic services like health, education, employment, and the environment. No. Because this law is really only on reproductive health and responsible parenthood. Number two, that argument fails to consider that the promotion of reproductive health and family planning is very cost effective. It does not need mega millions to be appropriated in order to achieve benefits for so many people, Your Honor. That's why we have quoted the UNICEF when it said that reproductive health would bring more benefits to more people at less cost. That is true, Your Honor. The studies would show that government is spending about 5.5 billion pesos annually for medical assistance as a result of high-risk pregnancies and maternal and infant morbidity. But the government will only use about 3 to 3.5 billion pesos in order to promote reproductive health and family planning. So there would be even a saving on the part of government, which savings could be used to augment services like education, health, and other requirements of the country. It is really cost effective, Your Honor. We don't spend mega millions for the promotion of family planning and reproductive health.
Would you agree with me that if the poverty level is only about 1%, 2%, or even up to 10%, it would be the disposition or the proponents of the anti-RH bill is correct when instead of spending billions for the contraceptives, it would devote much of its efforts in the health, in seeing to it that the health, the education, etc. of the people would be given time by the government.
Yeah, yes, Your Honor. That could be true if we don't have a problem on poverty and poverty alleviation. But even if we don't have that problem, it is still necessary that a reproductive health law should be enacted and implemented, because it really would promote further the health of women and infants, and as well as reduce the incidence of abortion.
All right, thank you, Mr. Congressman.